a lot before the break, and on brand with all of the ex-lawyers. Now we have some proper lawyers coming up. So I'd like you to welcome Leah Mooney and Veronica Scott to talk about generative AI and minimising the privacy impacts of high-risk technologies. Leah is a director at KPMG Law and is best known for helping organisations understand cybersecurity and data privacy risks and compliance, with a particular focus on data breach incident response, high-risk technologies and cybersecurity issues arising in the context of the security of critical infrastructure and countering foreign interference. Veronica Scott is a partner and lead of the cyber privacy and data practice of KPMG Law. She has more than 20 years' experience advising Commonwealth and state government agencies, not-for-profit and private sector clients. Veronica is a highly experienced cyber incident response lawyer. She also advises on complex, high-profile and sensitive legal issues, investigations, risks and projects relating to data, digital content, privacy, information security, cyber, data ethics and implementation of digital strategies. It's quite a lot. Welcome to the stage.
Thanks very much. I'm actually at Pinsent Masons now. I used to work at KPMG Law. It's not your fault, it's our fault. We didn't update it, but I joined Pinsent Masons a couple of months ago to set up their TMT practice. But anyway, it's not about me. We were here today to talk about generative AI particularly, but AI in the context of privacy, and we think as privacy lawyers why privacy is a really good lens in which to think about the risks of managing generative AI as a technology. So there's a lot of content, but we just want to really highlight some things and then get to questions. And we hope you do have some questions for us. So to start us off with, AI is not new. It's been around for quite a long time, since the 1950s, certainly well before my children and users of devices were born. It was coined in the 1950s in relation to sort of computer machines and the idea that they would develop to equal or exceed human intelligence in whatever form that is. Machine learning is probably what we're more used to these days in terms of thinking about the types of technology that we use in our organisations, and as a subset of AI, and then we're seeing the emergence of deep learning, and then more recently, of course, generative AI, which is relatively new on the block, particularly with the advent of OpenAI and obviously now Google and other technologies. ChatGPT, we're kind of in a post-ChatGPT 4.0 world, and we're really now looking at how organisations and individuals are bringing generative AI in particular into their everyday lives. The ChatGPT can be used personally, and also organisations are looking at how they will use it or ban the use of it within their organisations or use their own sort of on-premise optionality. Now we're really looking at, of course, many of your organisations will use, for example, the Microsoft suite of tools and Copilot. And what we're seeing through the emergence of the ability to uptake Copilot licenses, that AI is really sort of, it's transformational, and there feels like there's a big impact, and then it's sort of incrementally coming into our everyday lives as well as we use it as a workplace tool as well. So the idea is that it's kind of here to stay, but as privacy lawyers, as those who deal with data and data security risks, we really need to think about it and be very conscious of what that means for individuals and our organisations. With more and more of these AI-assisted tools being launched, and how we go about very carefully, optimistically considering the risks. So in terms of the definition of artificial intelligence from our perspective, Leah, over to you.
We're lawyers, we need a definition.
Yeah, we love a definition.
We need one here. And with AI, we are going to be focusing on generative AI today because that's where the main concerns are around privacy and the related risks. But I think it's important for us to talk to conventional AI. And that particular definition has come from CSIRO Data 61. Fun fact, the 61 comes from the Australian Country Code. Just, something to take home and chat about over dinner tonight. And you would have dealt with this type of AI in your lives for years before now. As Veronica said, this has been around for a long time. It's generative AI that's changing the position. The definition we've taken there is from Australia's National Science and Technology Council. And this is the type of AI that we want to focus on today. So that deep learning and probabilistic model to generate new data content or solutions. We also want to look overseas through that international lens because we have got some legislation in the EU that's world leading. Their definition of AI is worth looking at, and in Australia we're currently working out how we're going to legislate AI, so I know that they're looking very carefully at that. We've also provided a definition that's used by the UK there. And look, there are a lot of words on our slides, but we heard there was a competition for the wordiest slides, and we're keen to win. But importantly, this is information you can take away after today that's hopefully helpful to you.
So what do we as Australians think about AI? There's a few surveys that have been released over the last year that focus on how individuals think about technology and its intersection with data privacy or personal information. And really you can't think about AI, and particularly generative AI, without thinking about personal information, which is why we're bringing this privacy lens today. The OAIC, which is the regulator of the Privacy Act that administers compliance with the Australian privacy principles and the management of personal information, conducts and issues a biannual survey into community attitudes to privacy. And really the takeaways from that and a more recent government survey as part of their interim response to Safe and Responsible AI consultation they're conducting is that individuals are concerned about their privacy. They are concerned about how AI and sort of high-risk technologies are used to process their personal information. They certainly see the potential and are excited, and Australians are real adopters of technology. So it's this balance between, well, how can we harness AI for good, but also protect individual rights like privacy, which is fundamental to us all. People are still uncomfortable with AI and how that's used, largely because they probably don't understand how it's done, and we're not probably very transparent at the moment about how AI is used to process personal information and make decisions in organisations that impact individuals. So we've got this real challenge about sort of low trust, probably low skills on the one hand, as we accelerate towards using AI as well. So we're looking at calls for governments to develop policy and regulation and guardrails to protect individuals and their personal information. And on the other hand, you've got organisations like OpenAI and sort of Silicon Valley and the big technology providers saying, you know, this is the future, get on board. It's going to become effectively the public infrastructure, like critical infrastructure. It's going to become the new infrastructure in the future. So what does that mean for organisations when you're dealing pragmatically every day with how to procure, implement and use AI to improve business processes, operations, develop new products, procedures and improve your workplace? Scarlett Johansson, the latest sort of example in the news at the moment about the risks and dangers of AI. You may be aware this is actually an artificially generated image of Scarlett Johansson, who was in a movie called Her, as an AI, an artificially intelligent woman who somebody fell in love with, and more recently OpenAI reached out to her to use her voice, to develop synthetically and use her voice as part of their suite of tools. She refused, and now their synthetic tool, Sky, released a voice that sounds very similar to hers. So the lawyers have got involved. She has made complaints, and she is saying that her voice and her likeness of her voice is being used without her permission, and it's very similar. OpenAI has ceased using it for the moment out of courtesy to her, but there's this real tension between, you know, where the law, the guardrails, what is right or ethical, or what communities expect in terms of how generative AI is using and scooping up a lot of data about us to produce these really sort of impressive tools. So setting that scene, now we're going to go on to talk about really as a sort of lightning bolt for what are the key risks from a privacy and personal information perspective in the use of AI.
And I want to talk first about the privacy and data risks here, because to train generative AI, we're using techniques such as data scraping, or we're inputting data that may include personal information or data that may be protected by intellectual property protections. And there's not necessarily that proper attribution, the consents that might be required from a personal information perspective. So there are significant concerns around the privacy and data risks of what is actually inputted into these generative AI machines, to use a technical term. And that is the key risk that we're concerned with, and where the legislation interplays with the AI technology the most. Accuracy and reliability. So AI will hallucinate, as everyone in the room knows, and we have seen, I think the most common example is that there was a lawyer in the US, he used ChatGPT to write some submissions. It hallucinated some case law, they were included in the submissions, and the outcome was catastrophic from a legal perspective, because the judge then had to deal with submissions that included case law that didn't exist. And they say that AI is going to replace lawyers, but AI always gives an answer. It doesn't say it depends. So until such time as that's what it does, I think we're safe, Veronica.
And its sources. And
yes. Transparency is important too, and that overlays with attribution. And when it comes to attribution, there's a couple of considerations here. It's, do you know that something that you're reviewing has had AI involved in its creation? And how do you appropriately attribute something you have developed where you have used AI to assist you in developing that? And that's a challenge that we have, where if your organisation doesn't have appropriate rules and frameworks for how AI is going to be used within the organisation, you might be looking at something that a junior might have developed in consultation with AI and not know that AI has been involved. But it's also important for how you're presenting that information out into the world. So if you're using AI to develop a tender, or to write a LinkedIn post, or to write an article, what sort of attribution do you need to give? That transparency will be important. Sorry, I think I just
That's
had
right,
two.
I'm just moving on, but when you're finished, Leah, to pick up a few of the things that you were talking about there, because they're the sort of things that in our everyday lives we're doing using LinkedIn and all those sorts of things. But what we see with clients when they come to us is it's a procurement process. You're either procuring over the top of technology, you've got some AI, or you want to use a new piece of AI to either, from a marketing perspective, from a operational perspective, to undertake quality control, to listen to voice recordings and analyse those. There are so many use cases that we're seeing now from this perspective. The challenge you've got is that you've got this, if you think about an AI product lifecycle, you start off with the foundational model, the generative AI model that is then sort of publicly released, like ChatGPT. That becomes the foundation. So that's where all the data is trained. As Leah says, it's generally scraped because it relies on large data sets, and there's a whole load of issues about how that's done and whether that's lawful, which Leah will talk about shortly. And then once that's set up, then as the organisation procuring and using it, then you've got obligations to understand, well, how that model was developed, what is the documentation, were appropriate legal ethical frameworks applied, was the organisation compliant with applicable data privacy obligations, what is the nature of the data, has it been appropriately used? So often we use AI tools here that, for example, may have been developed from, let's say, from a health data perspective use for a clinical application on a certain type of population. But is that population's data fit for purpose to use and interrogate and then develop a response or a solution or advice for a population in Australia? So we know that when you're procuring AI, it's very hard to negotiate terms with some of these very big technology vendors. So really the risk is all being taken on by you. So as Leah said, you need to think about all of these things and have those frameworks and models in place so that you can decide what kind of risks you're going to accept. And when you're deploying it, then you have planned to manage those risks as they go in. So for example, how are you going to use it? What is your use case? Because at the end of the day, the legal consequence arises not only in the nature of the data that's collected and how it's used, but also the decision that you make in relation to that information, because that will have a legal consequence on somebody or on an organisation. And then that raises other legal considerations, which we will talk about.
And I think that ties in nicely to the bias and discrimination, because the theme of this conference is Pay It Forward. And we've seen, I think it was from the Human Rights Commission technology report back in 2021, but still relevant, racial discrimination has been identified where AI disproportionately targets minority groups, and recruitment algorithms prioritising male over female candidates. So obviously risks we want to avoid when we look at the legal and regulatory framework.
Definitely. So as Leah mentioned, the EU has now approved and agreed on the AI Act, and like the General Data Protection Regulation, is probably set to become the kind of gold standard for AI regulation. We're not there yet, and many other countries are releasing legislation, which we'll talk about. But what that really focuses on is a risk-based approach to use cases. So it identifies high-risk uses that are banned, then that sort of next level of medium-risk use cases that require certain compliance with a whole range of governance obligations, and then low-risk cases which are less regulated as such. There's a sort of argument that says, well, you kind of fix use cases in those buckets, and of course in the future we don't know what sort of use cases might arise. But they're very much focused on, for example, high risk in relation to the workplace, employment and recruitment decisions which affect our emotions or our social sort of rankings and ratings. So it's quite prescriptive, which is a very European way of doing these things. So I mentioned what's happening in the world. So Leah, in relation to legislation, where are we at? Are we regulated?
We don't have AI-specific legislation. There's no one law to rule them all, as they have in the EU. The main legislation that we have is the Privacy Act, which touches on AI, and more so the future state of the Privacy Act, because as you know, that there are some reforms that are taking place that are designed to bring it up to speed with current technology. But we've laid out there other legislation that touches on it, and particularly surveillance, because we've seen a number of case studies, which we're going to talk to later, where AI and surveillance have intersected with facial recognition technology and the like. I think we'll see more around critical infrastructure. I know the previous presentation touched on that, but particularly around how AI is being used to orchestrate cyber attacks. And we've laid out a number of other laws that touch on it, but we'll talk to what the government's proposing to do shortly. But supporting those laws is the current voluntary regulatory approach to AI. And there's quite a bit there, but what I do want to just touch on is the CSIRO AI ethics framework. Again, bringing this back to paying it forward. Ethics needs to be at the centre of these decisions that we're making in relation to how we regulate AI. And we're going to talk to the Australian Government's interim response to the Safe and Responsible AI consultation, which sets out the pathway for how it's going to be proposed. So the Australian Government has said, look, we're not going to have voluntary guardrails. We do want to have some form of legislation. They haven't decided whether they want to uplift some of those existing laws, which I talked to, or whether that will have a standalone AI Act like they have in the EU. But what they have said is they want to take a harms-focused, risk-based approach, a harm minimisation approach. That means that where there will be high-risk AI activity, that there will be some formal legislation that regulates how that works, and where there's low-risk technology, the guardrails will more likely be regulatory. So that's where we're headed. But what about the OAIC and overseas?
So where are we now? And that's why we bring it back to privacy, because the Privacy Act is the only act that really intersects really broadly as a foundation with data, personal information and technology. It's intended to be technology neutral and flexible, and it takes that risk-based approach. And we keep coming back to that. That is good in a way because it gives you that flexibility. It's not aimed at stifling innovation, but it requires a lot of hard work and thinking for organisations to understand, well, what are our objectives in relation to adopting AI? What sort of models are appropriate? What are our go, no-go use cases? How are we going to govern for this? The OIC has just recently appointed a new privacy commissioner. She has a very human rights lensed approach to things, and I think we'll start to see that a lot. because fundamentally there's going to be this constant tension between advances and innovation in technology and how we deal with the sort of existential threats that AI has to privacy. And so people might say, well, let's give up, the future's here, paying it forward, we're not going to bother, but that's what we're really trying to do. Regulation doesn't always keep up, but I think it's a really good opportunity for organisations to take all the tools that we've got, to take the foundations of the Privacy Act, and to apply that lens at least to how you're going to develop your management and adoption of AI. So, for example, you'll hear about things like high-risk privacy processing. So you'll be expected to conduct impact assessments, privacy impact assessments, in relation to those AI-related technologies that will impose or potentially raise high risks to individuals. And you may even need to lodge those with the Commissioner. So, you can really see that the regulator is going to be able to reach into your organisation and look at those decisions, the assessments you made, your risk findings, and how you have addressed those risks. Security is absolutely important. We see that privacy and security are the two sides of the same coin. There's no point having a really safe around your data if you are not properly using and processing that data in accordance with your legal obligations and the reasonable expectations of individuals. So both sides of those things are really, really important. The consumer data right, which you might have heard about, again, it's this real focus on how do we, as a society, as a government, in terms of policy, use and value data so that it's for the benefit of individuals and give individuals control back in relation to their data. And the consumer data right, I think we'll see it's been designated in open banking, for example, where we see a lot of AI being used, for example, in credit decision making, but it is being designated increasingly in other sectors. And as organizations look to what their commercial strategies are and expanding and reaching out into offering products and services across sectors and giving the control to individuals to choose those products, I think we'll see AI really play an important role. And importantly, transparency, and I think, Leah, you mentioned that, and from an ethics perspective as well. We're not seeing a lot of transparency at the moment around how AI is used to process personal information and make decisions. And certainly in advice and in impact assessments that we do, that's one of the questions that we ask and make recommendations about. International developments. Australia is a bit of a hybrid. So generally what we do is we see what the rest of the world is doing. We go away and have a really good think about it. We apply kind of our local lens, and then we kind of say, okay, well, we're going to do some stuff, but we're not going to do others. We're not going to rush into it. We're going to think about it. So we look at countries like Canada, of course, what's going on in the US, Europe, and then more closer to home, and New Zealand. And not a day goes by when there's another announcement about new regulation being introduced. So, for example, in the UK, they've adopted what we call a very principles-based approach, and they've said each regulator, so whether it's a regulator of the energy sector, the sort of SOCI equivalent in terms of cybersecurity, government needs to take an AI lens approach to how they're going to administer compliance with their sort of entities that are regulated by them. In Australia, we're kind of taking that hybrid approach, as Leah said, which is let's look at all of the regulatory tools we've got already. We've got a lot of legislation that applies to organisations. We expect compliance with that, but we might need to see an uplift and a strengthening in some of those areas. Interestingly, in the UK, a private members' bill was introduced by Lord Richmond in the House of Lords, which actually, usually these things fall away, but that AI Act has actually been really welcomed, and that introduces concepts like requiring organisations to have an AI officer. And we know that a number of organisations now do have and have appointed AI officers, and it again brings a really strong privacy lens to those types of requirements. So, informing us about why this legislation is going in a particular direction and the regulatory appetite to how organisations use AI, it's always worth looking at what sort of case studies have already happened and what are the attitudes to that. So, Leah, Australian experience, what have we seen so far?
So we know that there are currently, before the OAIC, 2 investigations in relation to Kmart and Bunnings. I talked earlier about that intersection between surveillance and facial recognition technology. So both of those investigations relate to facial recognition technology being used to target shoppers in those environments. I think Good Guys was initially tapped on the shoulder, but are no longer part of that investigation. I think everyone's familiar with the Robodebt matter, and it does very much highlight, when we talk about high-risk technologies, that use of AI to make decisions in relation to individuals. In that situation, we had almost 500,000 individuals who were wrongly issued debts as a result of that Robodebt making decisions in relation to it. So there's a Royal Commission in relation to that, and that has very much an important learning for how we go forward.
And Leah, I think for that one as well, everybody sort of said, well, that's traditionally AI, and when we come back to a definition of AI, what happened in that wasn't what we think about as generative or any new type of AI. It was technology doing what technology was supposed to do, but then it was how individuals and organisations used it to make decisions, and then the oversight, and then once you identify if there's an issue, how do you remediate that to make sure that that negative impact doesn't carry forward? And I think there's some really important lessons to be learned there.
That's right. It's not just about traditional versus generative. It's about the risk of the AI we need to be concerned about. I think you were going to just touch on the Trivago case briefly, and then I'll talk to Clearview.
So Trivago, we're all users of trying to get the best price for our hotel room booking. Trivago really wasn't about a sort of privacy-related issue. It was more about misleading and deceptive conduct, but again, around our consumer rights, the right to be told the clear information about how an algorithm was making decisions about the types of hotel room booking offers and prices it offered us. And the ACCC took enforcement action and found that Trivago had basically been putting to the top of its list and showing consumers those hotel room bookings that it received click per pay. So it was being paid by those hotels. So you weren't actually getting the cheapest deal, which is what you thought you were getting. And we've just wanted to highlight that's that whole concept of what we're representing to individuals whose information we are using to either make decisions about them or to make other decisions that have a more broader sort of community perspective.
And Clearview AI is important because it's a privacy determination. It was a joint investigation between our Privacy Commissioner here in Australia and over in the UK. And what Clearview was using was effectively data scraping technology, where it collected biometric information in relation to individuals, 3 million individuals with our consent, and used it for a facial matching service that was offered to law enforcement and the like. And in the previous session, the session before that with the talk around data breaches, this was talk around sensitive information. So biometric information is sensitive information. You generally need consent to collect it unless an exemption applies. And so Clearview was found to have breached several of the Australian privacy principles around collecting that sensitive information without consent, and also the way that it was collected and used. So it's a useful case study. The other one is 7-Eleven, which was using facial recognition technology for individuals who were completing surveys in stores. So those determinations are a good place to go to see how that privacy law intersects with this technology.
So the global outlook, which we can see what's happening there, will eventually come here. Leah mentioned that data scraping. This is where we're really sort of regulators and governments are looking at how do you balance those rights. So, for example, in the UK, the Information Commissioner there is consulting with industry to ask them about, well, how should we think about what generative AI does in terms of scraping and collecting all of the information that it inherently needs to be able to develop the technology. Privacy law says you should only collect personal information that's reasonably necessary for your functions and activities. If you were developing generative AI, you would argue, well, any information that's available publicly on the internet is fair game, and it would be reasonably necessary for me to do that because I have this vision of the future that generative AI is going to play such a critical role, and the improvements that we can make in this technology really depend on more and more data. On the other hand, I hear that actually it's run out of data and there's not enough data. It needs more data to actually continue to develop. So there's this constant sort of cycle of needing data to develop the technology, but then how do you manage the privacy risks of that? Thinking also about data minimization at the other end, which is what we really are hearing now, particularly as a result of those very large data breaches that have happened more recently, which is don't keep what you don't need or what you're not using, safely delete it. But of course, if data is this kind of oil or water or lifeblood of what AI needs to develop, then how do we go about doing that? So I think what we're going to go into now is really talking about some of those tools quickly.
And of course, not just deleting it, but not collecting it in the first place.
Not collecting it in the first place. So we talk about sort of the hierarchy of needs from an AI governance perspective. And we say, don't throw the baby out with the bathwater. You know, it's not the Wild West, I think, is what the Asset Commissioner said in relation to how organisations should deal with AI. There are rules and regulations. You need to comply with the law. A lot of big technology providers talk about, you know, ethical compliance, meeting community expectations, but you may have heard the expression coined ethics washing, like greenwashing. It's kind of potentially a way of avoiding saying, well, does our technology, in terms of the role we have, whether we're developing it, using it, making decisions about it, comply with the law? So as a baseline, are you complying with the applicable obligations? We call that the hard law, the legislation. Then have you got contractual obligations, whether downstream or upstream in relation to how you're using that technology and the personal information that you're collecting? And you go to all of those sources that Leah mentioned. We don't have a lot of case law yet, which is, as lawyers, we like case law because it's a way of saying to clients, look, this is what the courts will say if you don't follow this, and then you'll have a penalty or a financial outcome or a consequence, and then that provides you with the guardrails for making those decisions. The guardrails are still emerging. We're still waiting, for example, for Internet of Things standards, you know, the sort of seatbelt in the car type rules to be wrapped around technology.
That's why those privacy determinations are so important.
That's
because
right.
that's all we've got at the moment.
That's all we've got at the moment. We are seeing some decisions overseas. Largely at the moment, they're focusing around copyright, for example, the use of media content by OpenAI, or in France, Google has recently been fined because the regulator argued that Google hadn't paid the media sufficient amount of money in exchange for using their content for their AI purposes. Then as you go up that pyramid, of course, look at standards, frameworks and guidelines. There's ISO standards now that have been developed, and they're really important because what we need to see is interoperability. Data flows across borders. So how do you make sure that wherever that data is being collected from, transferred and used is compliant with consistent standards? So from a security perspective, you know, we always ask, well, are you aligned to or do you certify or comply with ISO 27001 or the NIST cybersecurity framework, or a combination of these? Ask the questions. Are we following, or is the AI developer or the vendor that you're using, have they followed any particular ISO standards in relation to the technology development and the management of risks? Have they undertaken privacy or algorithmic impact assessments in developing the model?
It ties in with those ethics. So in the same way as cybersecurity, those organisations that choose to put an individual first and make cybersecurity, good cybersecurity their brand, using, getting towards the higher end of this pyramid around the ethics, the principles, the values, the ESG issues, that's where you're going to really have a differentiator from an AI perspective.
And then lastly, your values. And that kind of works at the top and then backwards as well, because in an AI governance model, you need to start with what's important to your organisation, what are the things, and how are you going to look at how you adopt AI, which then will influence how you set up that governance model. Are you going to have use cases which are simply no-go? Are you going to let businesses innovate and test new things? How are you going to upskill your workers to actually properly use AI and use it safely? And what we find is that there's still a lot of learning to be done around understanding about how to manage the risks in relation to personal information. Once you bring AI into it, everybody just panics. So we kind of say, let's go back to first principles.
So I think we're going to share these slides. So I think we'll make the privacy impact assessment. Privacy impact assessment is one thing you can do to try and make your AI as safe and responsible from a privacy perspective as possible. But we might just skip to questions. We want to allow some time for those in the room to have some questions.
Yep, really happy to do that now because we've been given time and
Awesome.
Thanks.
Thank you so much. We'll go straight into questions. I'm going to skip over the ones that veer into the legal advice for some crimes about to happen. But for a good general case, it depends. Yeah. And I'm sure there's some advice to be had outside the room. But so George has had a couple of good questions here. Is there any legislation on impersonation attacks where imposters use AI to fake being another person? Are there specific fines for that, or is it more about the unauthorised use or the delivery of doing crimes with the AI models or the AI models created? So the Scarlett Johansson one is obviously...
I think it depends as well. Again, you have to think about it in terms of where you are in that life cycle. Are you developing the model, or are you procuring it for a particular use? So if you're doing it for a creative purpose, it depends how. Are you misleading anybody in relation to the creation of that? So you may have heard, I think it was in Hong Kong, there was an employee who transferred $35 million because he was asked by the CEO or a senior person to do that via email. He was suspicious. A meeting was arranged because he challenged that. He had a Teams meeting and there was an AI-generated avatar of his boss telling him, no, it's all good, you can transfer that data. So that is a criminal offence right there.
And that's right. It's where the traditional law intersects with the new technology. So what we might see is, rather than a standalone, don't use AI to do this, is that there might be a change to some definitions in criminal or other laws to ensure that those sorts of offences are captured.
Yep. So for now, it's still around intent, but there's potential changes.
And most of the legislation is around what is the harm, what sort of parameters do you need to put in place or framework do you need to put in place to minimise that.
Okay. And then we've got some sort of related questions around the segregation of AI. We're all checking a box that says, please don't use my data to train your models. What is the likelihood, and this comes from Tom and from Nathaniel as well, how can we remove information that's inadvertently been used to train the AI, and kind of linked into the how can we build safeguards into this when it's evolving so quickly and we don't really understand and we can't query the AI to understand how it's used that data in the first place?
So I think the really important thing is first to think about what systems are you going to allow AI to access. So even think about Copilot. I think the Victorian Privacy Commissioner talked about this during Privacy Awareness Week and Power Up and Pay Forward Your Privacy, which is when you're going to allow AI into your environment, you want to really, really control that. So you don't want it anywhere near any systems where you could have inadvertent access. And what we see a lot, particularly in data breaches, is there are those access controls that have failed, or there's the machine that is being accessed that nobody knows about. So that's really important. It is a bit of a black box, it is opaque, and that's where you have to do your due diligence to ask about that and manage the data that you do allow to be inputted that you're happy with. But what we're seeing now, and I know from KPMG's perspective, they've got an on-premise sort of chat GPT and KimChat, where you're only using your own data in a controlled environment for your users to use it in appropriate ways that you've agreed and tested that they can.
And it intersects with that Clearview case study we had said earlier, because generally you don't need consent to collect most forms of personal information, but where it is sensitive, you usually do. So hopefully that Clearview decision and the other decisions that will follow that will help to prevent data scraping, because there's not very much you can do from a legislative perspective right now other than to make a privacy complaint.
Yep. And that leads quite nicely into Trinity's question, which was partly answered by the Trivago example. But have there been examples of legal action taken against organisations where AI tools have introduced unethical or illegal practices, such as discrimination in recruitment?
Yes, there have. They're not necessarily in Australia. There are some in the US and the UK, and then the regulatory authorities in the EU are looking at those sorts of things. But I think what we're seeing is it's really back to what Leah's saying is it being brought as a privacy type complaint, or is it being brought as a misleading, deceptive sort of consumer law type complaint, or, for example, in the context of what we see, I think, in America is education environments, so where inappropriate use in relation to students breaches their children-based legislation.
And maybe not in the discrimination context, but in the privacy context, one of the proposed reforms is to introduce a direct right of action or a tort for serious breaches of privacy. So we will, I think, start to see more litigation around privacy that we're not seeing now in Australia.
Yeah, and I think Amazon's had some challenges as well with some of the products that it's released.
Yep. We're getting very close to time, but I'm going to tie another couple together. So Andrew has asked, what do you mean by the AI officer within an organisation? What would that role encompass? And once you've got that person, they will probably answer Sankar's question, which is, do we need to perform privacy impact assessments of AI-driven security tooling used for detection and response where they're collecting, he's listed information, but basically information that you could reasonably identify an individual from?
So answering those in reverse.
Yeah, so you definitely need a privacy impact assessment. If you're looking to use any form of AI that is going to intersect with personal information, please do a privacy impact assessment. Two purposes: it will help you to identify risks and introduce controls to mitigate them. But also what we're seeing with the Privacy Commissioner is, after there has been a complaint of an alleged interference with privacy, they're saying, did you do a privacy impact assessment beforehand? It's a key regulatory priority. The former Privacy Commissioner spoke about it a lot, so definitely do one.
And to add to that, there is now this idea of a human lens, so bringing a sort of human impact assessment. So the Human Rights Commissioner has worked with NAB to introduce a sort of ethical human design-based impact assessment. So it's really an expansion of the types of things that the PIAs do. So have a look at the Human Rights Commissioner's website. There's some really useful guidance there, and the Ada Lovelace website as well, because they developed one because they were working, I think the National Health was in the UK is working with Google DeepMind, and so they developed one.
And the Privacy Commissioner came from there too.
And the Privacy Commissioner came from there. To answer the other question, AI officers, we've seen a few of them. In Europe, you've got data protection officers, so organisations which process quite a large amount or personal information or sensitive information need to appoint a data protection officer that is independent, so they've got a very particular role. We don't have that yet here. We are expecting that organisations might be required to appoint a senior person to be responsible for privacy. Again, we see that kind of hybrid approach in Australia. The idea of an AI officer, and you know, I heard somebody say, you know, how many chiefs, how many sort of C-suite do you need at a table? How many hats do we need to be wearing? We see this done by the chief data officer, for example, taking that kind of role. But certainly in highly regulated organisations, we have seen this AI officer. They're relatively new. They kind of emerge from data ethics, privacy, data management type roles, but with quite a technical perspective, I think. So it's a kind of watch this space. But when you put together an AI governance model, what we say is that you need a combination of skills and people at that table. So even if you have an AI officer, they can't do all of these things by themselves.
I'm going to get into trouble, but just to keep Scott out of the watch house tonight, he's wondering if he wears a balaclava into a local store and gets arrested, would his right to protect his privacy from facial recognition cameras be a valid defence?
No.
Thank you so much.
No expectation of privacy when you commit a crime.
Yeah. If anyone wants to track our wonderful legal advisors down, I'm sure they'll be able to answer more questions later. If you could give me a welcome, if you could join me in thanking Leah and Veronica for an awesome talk.
Thank you. I'll take one of these down the back.